Yeah, look, Minister, we discussed this in detail. I know we've discussed it privately as well in relation to protecting the victims of previous crimes from harassment from the convicted sex offender following their release from prison. And sadly, Minister, this is all too common in terms of intimidation. And it is covert intimidation that takes place. So it is nearly impossible for the Gardaí to be in a position to secure a conviction in relation to the way the law is at the moment. And the law is more broadly in relation to harassment, and I can understand that. But there is previous here, there is history here in relation to this, and this intimidation is undermining the ability of the victim to get on with their life. Now, I know at committee stage you said that you wouldn't deal with it in this particular piece of legislation, that there was further legislation coming forward, you were going to address it in that, and you just might provide clarity regarding your intentions and the timelines for that. Thank you.
Look, I would completely agree with you. Whether it's stalking, harassment, whatever we call it, it absolutely ruins people's lives and can have a devastating impact. But I know in particular there's a certain situation that we are both aware of where a horrendous crime has been committed, a person has served time and is now potentially continuing that level of harassment. I gave a commitment that this would be dealt with in a separate bill. The harassment and harmful communications bill was obviously dealt with, but more recently, last week, we had second stage of the criminal miscellaneous bill, which introduced stalking as a standalone offence for this first time. It expanded out the harassment offence, but it also introduced a new system of civil orders around stalking type behaviour. So obviously one of the big challenges here is for somebody to have to go back to court and get a criminal go through a criminal case again with a person that they've gone through this before. It can be quite daunting, it can be very difficult, and obviously the threshold is perhaps much higher to have that succeed. What we're saying with the civil order is that it does not require criminal prosecution. It is something that would require a lower threshold where I suppose you can make it clear that a person's behaviour might likely impact on a person's well-being or their mental health or their state of being, and I suppose it would be much easier for either an individual or a member from Garda Síochána to get a protection order against another person in the civil courts without having to go through that criminal trial. So I appreciate it does mean a person has to go through another process again where they might have already, but I think we have to accept that if a person is convicted of a crime, they have served a time, then obviously there is no way to go back on that unless there's a particular order or something that has been put in place by the judge at the time on release, that there are certain conditions that they have to comply with. And that is still the case, that can be said by a judge, or there can be certain conditions put in place. But if that does not happen, what I have set out here I think is a much easier, a much more simplified process that would allow somebody to impose a restraining order on someone whose actions and behaviours might not meet the threshold for stalking or harassment, but certainly their actions to a reasonable person could inflict a lot of harm on an individual. So that bill passed second stage just last week with the support, obviously, hopefully, of the Justice Committee and others in the House. I'd really hope that legislation would be enacted by the end of the year, so it would very much be in line with this legislation in terms of timing. Thank you.
Thank you, Minister.
Has the amendment been pressed?
No, withdrawn.
Withdrawn. Moving on now to the next amendment, Amendment 35, in the name of the Minister.
Thank you. So this is something we discussed previously. The purpose of this amendment is to ensure that a prohibition on working with children or vulnerable people can be imposed on life sentence prisoners. So by deleting the text for a specified term, any ambiguity I think is removed around whether or not this can be applied to life sentence prisoners. As you're aware, the most serious crimes against children carry a life sentence, and I want to be absolutely certain that a court can impose a prohibition on these offenders. We had a discussion at committee stage, and colleagues I think raised very interesting and valid points around the application of prohibition orders on working with children and vulnerable people. Legal advice was sought by my department with the AG, which confirmed that a prohibition on work is a penalty, it's not a civil order, and therefore, when added to the prison sentence, can't constitutionally exceed the maximum penalty for the offence in question. So, again, I just want to reassure deputies that there is a suite of legislative measures which prevents convicted sex offenders from working with children. They include the National Vetting Bureau, Children and Vulnerable Persons Act of 2012, and the core obligation of that Act is in section 12, which provides that a relevant organisation shall not employ, enter into a contract or shall not permit any person to undertake relevant work or activities without vetting done by the National Vetting Bureau of An Garda Síochána, and failure to comply with this is a criminal offence. So really this is just making sure that by deleting for a specified term, we ensure that the life sentence term actually comes in under this and that it can apply to someone who receives a life sentence for this type of crime. Thank you.
Okay, so the question is that the amendment be made. Is that agreed? Agreed. Amendment 36 was already discussed. Withdrawn. Amendment 37 in the name of the Minister.
Thank you. So I move Amendment 37. This amendment arises from the transitional provisions and saving arrangements provided for in the Garda Síochána Functions and Operationals Area Act 2022, as the Sex Offenders Amendment Bill 2021 will be commenced first. So we had thought that the other bill would be commenced before this, so these arrangements will become redundant. Amendment 37 repeals Section 7 of the Garda Síochána Functions and Operations Areas Act 2022, Section 7 Amendment. Section 7 amended Section 10 of the Sex Offenders Act 21, made provisions for a sex offender to notify at any divisional headquarters or any station nominated for this purpose by the Commissioner. As this bill will be commenced first, this section is currently no longer required. Transitional provisions for the Sex Offenders Act 2001 were also inserted into the Act of 2022, so these again likewise no longer will be required and therefore they're being deleted. So it's a technical amendment.
Nobody indicating so. The question is that the amendment be made. Is that agreed? Moving on to Amendment 38. Oireachtas Naughten.
Minister, we're now moving on to the two final amendments in relation to issues that we discussed at committee stage. And I think probably the second key weakness in this law, and I've highlighted the first key weakness in relation to my amendments earlier, but the other key weakness is the failure to close off the loopholes that allow sex offenders to have their offences effectively forgotten through the change in the offender's name by deed poll or by using the Google right to be forgotten. And for the sake of victims who have to live with the consequences of these perpetrators and any potential future victims, those convicted of sexual offences should lose that right to be forgotten permanently. Now, Minister, as I've said to you before, the only test that Google seems to use to reply to a request to be forgotten online is to, and have the court reports erased, was the length of time since the material went online, which is not in the public interest, I believe, and Google do not consider what is in the public interest when they remove access to this information permanently regarding a court conviction. And I don't believe, Minister, regardless of any court conviction, whatever it is, that there should be the possibility of having that information erased. Because, as you know, court hearings are, except in very exceptional circumstances, to be held in public. The decisions are to be in public. In general, those convicted, their names are published, and all of that information is now available through the electronic format. It is the main primary record now of courts and public proceedings in this country, and there is no legitimate reason why the likes of Google should be allowed to remove those listings, because it is an exploitation of EU privacy laws. There is provision within the GDPR privacy laws to ensure that the public interest is protected. So the GDPR does allow for, in circumstances where a convicted sex offender looks to have the record of their conviction erased, it does allow for a situation to arise where Google and other organisations can refuse to erase that information. But that is not applying here. And Google have to date defended its handling of requests to delist articles relating to such criminal convictions on the basis of the amount of time since the conviction took place. And that is the only consideration that they are giving in relation to it. Now, Minister, I do not believe that that is satisfactory. I do not believe that it is good enough. And I am asking that you would take a proactive approach in relation to this, that you would bring Google and other relevant organisations into the department and make it crystal clear to them that we will not tolerate a situation where the records of sex offenders are delisted from Google searches or any other similar organisation, that they will not allow that to happen. As I've said to you before, Minister, this is a further abuse of the victims of these crimes, that their story has been erased. And, you know, there is a huge amount, sadly, of pressure put on victims, inadvertently, but pressure put on them to waive anonymity in many cases so that they can ensure that the sex offender is named. And it is wrong, Minister, after they going through that trauma, after they releasing their name into the public domain so that the names of the perpetrators could actually be exposed, could be published, to find out down the road that the likes of Google has actually delisted that. That is a far greater abuse again. And I believe, Minister, that we as a country, you as a minister, need to make sure that this practice is stopped, immediately, and that those records remain permanently available. Thank you.
Thank you, Deputy. So the General Data Protection Regulation in the EU is determined and is interpreted by the European Court of Justice, and I think the Court has been absolutely clear in saying that where there is a serious offence, and a serious offence will include rape, sexual assault, abuse, there is absolutely no right to be forgotten. There is a right where it is a minor offence. You know, we talk here about trying to work with people who want to change their life and turn their lives around, where minor offences have been created, and obviously having this impact where they might be applying for jobs or impacting their personal life, where it's a minor offence. I think we can agree it's something that obviously is not at the same level where a serious offence has been committed. But I have to stress that a sexual offence of any nature is never going to be allowed to be forgotten. I'm not aware of cases. I'm not aware that there have been cases won by any of the companies, because time has lapsed, and obviously if there are cases that can be presented to me, but this is absolutely clear. I would share the Deputy's concerns that if these types of cases were being removed, it would be a very, very serious offence. But at the moment, it is absolutely clear, the Court is very clear how this is interpreted. Any type of sexual offence cannot be removed. There is no right to remove it. It is in the public interest, and it's absolutely vital that victims know that, and obviously that they are reassured by that. I do engage with different companies. I have met recently with Meta or Facebook on the issue of working with them to make sure that every protection and every measure is put in place to prevent and to support victims of sexual abuse, domestic violence, assault, and making sure that technology is used for the better to support people, because as we know, as technology evolves, there are those who wish to use it for their own good or for their own reasons, which obviously can have significant negative impacts on people, whether it's for abuse or other reasons as well. So the companies themselves, there's an obligation on them to protect the people who use their platforms, but the law is very clear here. There is no right to be forgotten in any type of a sexual offence, and if that were to change, or if there were to be court rulings to that effect, it's something that I certainly would be raising at a European level. Thank you.
Sorry, Minister, and I only have a short period of time, but for example, Shane Phelan on the 13th of November 2021 published an article, Pimps and Sex Offenders Among Those Using Right to be Forgotten. And he pointed out in the article that press coverage of activities of criminals who have been behind multi-million euro vice rings have been forgotten by Google following requests under EU privacy law. And it goes on to give examples of where this has been used to delist very serious criminal offences. The Irish Independent is also aware of the delisting of at least 3 articles relating to the conviction of men for possession of child sexual abuse material. And this is only from last year. So that is in the public domain. It talks about other cases in relation to it. It is going on, Minister. It is happening. Google is facilitating this as we speak. They are regulated from this country. I believe there is a responsibility on us to protect women and children throughout the European Union by ensuring that what is the law, what has been set out in the European Court of Justice, is actually applied here in Ireland. And they are just a couple of brief examples within the time I have. And I would ask you Minister, to engage with these organisations on the basis of ensuring categorically that these cases are not delisted, particularly where people have lifted the right to anonymity, to end up in a situation where Google decides that this will be concealed again.
Thank you. Deputy, what I would suggest perhaps is that we would meet following this to look at the cases that you've referenced, and I absolutely commit to raising them directly with Google and seeking a meeting with them. I would be appalled at the idea that somebody who has been convicted of possessing child abuse material, that would be in this category. As I said, I wasn't aware of the cases you've mentioned, but very happy to meet with you to go through it and obviously to raise it directly with them. Thank
you. Withdraw the amendment on that basis.
Amendment 38 withdrawn, and moving on to the final amendment, Amendment 39. Again. So,
Minister, this is a related issue, and at the outset I want to thank my colleague Sarah Campion, an MP in the UK, and Lucy Serna, her advisor, for their assistance in relation to this issue, because this is an issue both in Ireland and the United Kingdom, and that is whereby a sex offender can change their name by deed poll in order to circumvent the monitoring under the Sex Offenders Register. Now, there have been published examples of this in the UK where it's happening. I have in this House given an example previously of a Terry Price who committed a string of sexual offences over 3 decades and changed his name on 5 occasions. But I know from talking to Gardaí here, who are involved in the monitoring of sex offenders, that it is nearly a standard procedure now that convicted sex offenders are changing their name by deed poll to ensure that they can avoid monitoring, to ensure that they don't come to the attention of people. Now, I haven't been able to draft an amendment to the legislation here. My colleague in the UK hasn't been able to do it either. This is a problem across both jurisdictions in relation to the use of deed polls to actually change names, to restrict the ability of the Gardaí to actually monitor these offenders, and we do need to address it. Now, I know that you're going to come back and you're going to say to me, well, look, if a sex offender changes their name under this legislation, they have a responsibility to inform the Gardaí of that. What I'm asking, Minister, is that the courts service, when someone changes their name, that this information is made available to the Gardaí so that they don't have to wait for a sex offender to come and declare it, that it is actually done through a third party and through the court service, and that the Gardaí are updated of that fact as it happens rather than at some stage down the road. Now, the difficulty is that we have a very high rate of breaches of the existing sex offenders register that is there. I believe that this legislation will give Gardaí tools to effectively monitor sex offenders, but leaving loopholes in the legislation that can be exploited by convicted sex offenders makes it more difficult. And this is one loophole that is being exploited both here in this jurisdiction and in the UK, where the mechanism to change your name by deed poll is being used to try and avoid monitoring, to try and avoid detection, and it is an issue that does need to be addressed. It's one that the Gardaí that are actually monitoring sex offenders around this country have brought to my attention as saying this is a specific problem that we are dealing with and we need to have the tools to do that. Now, I accept it's a complex area, and I think the easiest mechanism around this is that there will be a clear provision or a direction given to the court service to make the Gardaí aware of changes that would happen, and that will get around this issue and I believe ensure that the far more effective monitoring of those high-risk sex offenders who have a determination to exploit again, and we do need to ensure that every possible avenue is closed off where that is feasible. And I accept there will always be risks here. We can never be 100% certain, but let's ensure that we can close off as many of these loopholes as possible. And I'd ask you, Minister, to consider my proposal.
I suppose, Deputy, there is no legislative basis for changing your name by deed poll, so we can't prevent or stop an offender from changing his or her name. But what is very clear, and you have alluded to this, is that if a person were to change their name from the enactment of this legislation, they would have 3 days to notify. And the fact that there is strict monitoring requirements if a person were to change their name and to not engage, to not notify that had happened, they're obviously, again, as I said, they're facing prosecution, they're liable for a fine, 12 months in prison, anything up to 5 years, €10,000. You know, there are significant fines, but also penalties in this regard. Have at the same time, based on our conversations at the committee, we've engaged with the Gardaí to be absolutely clear that they are happy with what we're proposing here, that there's nothing further that we can do. And they're clear that they don't believe there's any further legislative requirements that are needed or any changes that are needed here, because of the fact that they have to notify very quickly due to the requirements that are already on them. Now, in saying that, I'm happy to look at this further. I'm not going to accept amendments because it places a very clear commitment that there will be a report before the Houses in 6 months' time, but I'm happy to follow this up further to see if there's anything further, be it through the courts or otherwise, that can be done to, in some way, provide further monitoring. But as I said, speaking to the Gardaí, who I appreciate they're one part of this, they have said they don't need any further legislation on this, but I'm happy to explore this further and to see if there's any other measures or any other involvement from any other state bodies that could perhaps support us in this regard.
Look, Minister, I'd say the people that you've been talking to, the Gardaí, and the people I've been talking to are very different. I've been talking to people at the coalface that are enforcing this. Now, absolutely, there is a requirement within 3 days of changing their name by deed poll to notify a divisional Garda headquarters somewhere in the country. And this comes back to the argument we had at the start of this debate. You know, someone who is residing in County Roscommon changes their name by deed poll and then informs the Gardaí in Wexford that they've changed their name. They've complied with it. And then, along with the hundreds of other emails and activity reports that updates that the Gardaí get in Roscommon, in the middle of them, buried in the middle of them, is the one in relation to this individual that has changed their name. And they are supposed to be able to pick that out and ensure that that person is being appropriately monitored. The difficulty is here, Minister, we are creating additional barriers for the Gardaí to actually effectively monitor sex offenders who want to go under the radar. And I cannot understand why, in those circumstances, contacting Wexford Garda Station in relation to someone residing in Roscommon or Galway or Mayo is appropriate or acceptable. I don't believe it is. What I would like to see happen is that the court service would inform the Gardaí, and that the Garda authorities would then inform the member of the force who is monitoring that sex offender in County Roscommon, in County Galway, or wherever the case may be in the country, of the change in name. That ensures that we have an effective and robust register. Don't let this legislation go through with the anomalies that I accept the House here voted for earlier on, and this particular anomaly as well.
Again, I suppose, look, this is something that we've engaged with the Gardaí on. So, I mean, I have to engage with the Commissioner, his team, who represent those who are working on the ground. And I have engaged on certain elements of this legislation with Gardaí locally as well. It's never an easy situation to monitor sex offenders, full stop. And obviously what we're trying to do with this legislation is improve the laws that we currently have, but improve the way in which the Gardaí can monitor, how they can do their job, and that we support them as much as we possibly can in what is always going to be a very difficult and complex situation to monitor anybody. But, you know, it's not that a person has to notify by email. They have to come into the station, they have to be there in person, they have to present themselves, and if they don't, there's a very serious penalty in crime. And I appreciate there are going to be people who don't want to comply, who try to evade it. And it's the very nature, as I've said, of monitoring in the first instance. These are not people in prison, they're out in the community. It's a very challenging environment, but that's why we've tried to bring in the amendments that would restrict their ability to evade, that would support the Gardaí in the best way possible. But again, I'm not saying that this isn't something that I won't work with you on to see if there's something further that we can do. As I said, the amendment is very specific around a report before the Houses in the next 6 months, but I will give you a commitment to look at this and to see if there's other ways that we can support the Gardaí in this regard. Thank you.
That completes the discussion on the amendments now. Agus inis lenam mudirai higan kuigo game. We now proceed to the 5th stage. Thank you. So I'm asking the Minister to move that the bill do now pass. Any contributions?
Just very finally, Minister, can I thank you and your officials for your engagement on this. As I say, this piece of legislation is in the offing for the last 13 years. I want to thank your predecessors, Alan Shatter, Francis Fitzgerald and Charlie Flanagan, for the work that they carried out in progressing this legislation. And the officials and their predecessors that I dealt with down through the years in relation to this, and caused plenty of grey hairs to over the last 13 years. While I'm not happy with the final bill, I think it could be better. I think this is a very significant improvement in relation to where we are. I think it will mean that we have a sex offenders register in this country that can actually be enforced by the Gardaí. I want to thank you, Minister, for taking on board many of the suggestions that I've put forward in relation to it. And I would ask you that during the passage through Shannon Airden to review some of the comments that I've made, see if we can provide further clarity, because at the end of the day, it is in all our interest to ensure that we have as robust a piece of legislation as we can. And as I want to finally say, Garamila Magov Galer, in relation to the work that all of you have done in bringing this legislation to this point. Thank you.
Minister, to conclude.
To thank all of my colleagues in this House for the support of the passing of this bill. It is a really important piece of legislation. The whole objective of this legislation is to support and to enhance and to improve the management and the monitoring of sex offenders in this country, in our community. And I think that the measures that we have brought in, and I'm sorry to hear that you're not happy with the final piece, but I think it is a very good piece of legislation that has come about following a significant amount of cooperation across all sides of the Houses, working with An Garda Síochána, working with the probation service, and I think it feeds into a much broader body of work that's been done by my own department, trying to deal with and tackle domestic, sexual and gender-based violence. So it is a very welcome, a very important piece of legislation, and one that I hope will provide much more protection to people right across our communities. So again, thank you to colleagues. And thank you just to my officials and those who've worked on it obviously for quite a long time.
Thank you. So it's